Hello everyone, my name is KIRTI Mehta and today we are going to understand about Memorandum of Association and its various aspects. So let's begin with the definition. According to Section 2 of 56 of the Companies Act 2013, memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this act. So basically MOA is a charter of a company as it defines the scope of the company's activities including its limitations and powers. Now what does MOA simply mean? It is a base on which the company is actually built. The basic purpose of MOA is to serve or provide to the investors or the shareholders about the knowledge and overall insights of the company before they take any decision on investment. After having a brief understanding on what is MOA, let's focus on why was MOA formed or what was the objective and what is the format of MOA for various types of companies. Objective of MOA. A company can undertake only those activities that are mentioned in the MOA. It helps the creditors and those intending shareholders by providing basic facts about the company like its powers, limitations so that they can make a sound and right decision before they actually invest. Basically, it lays down the boundary beyond which the actions of the company cannot exceed. Format of MOA. As per Section 4 of the Companies Act 2013, companies shall form the MOA as specified in Tables A to E in Schedule 1 of the Act. This means that as there are various tables for different kinds of companies, a company shall adopt only that table which is applicable to it. Let's know what each table means. Table A. It is that form which is applicable to the company that is limited by shares. Table B. It is applicable to only that company which is limited by guarantee and is not having any share capital. Table C. It can be adopted by that company which is having a share capital also is limited by guarantee. Next, Table D. It is only applicable to unlimited companies. Last one, the Table E. It is suitable to the company that is having a share capital and at the same time is a unlimited company. Moving towards the last topic, it is the contents of MOA. It includes the 6 clauses which is explained as follows. The first one is the name clause. It states that the company's proposed name. It must end in the word limited if it is a public company and private limited if it's a private company. It can't be same to any existing company's name and it should not be misleading in any way. The second one is the registered office clause. The registered office clause lists the name of the state where the company's registered office is physically located and also confirms the company's nationality. The third one is the objective clause. It is the most important clause as it defines and limits the scope of the company's operations. It protects the shareholders' funds and also ensures the funds will be used for the specific business purposes for which they are raised and they won't be raised in other endeavors. The fourth one is the liability clause. It explains what liability each of the company's members faces. If the company is limited by shares, the liability that each member faces can be not more than the face value of shares that he or she holds. In case if it's a company which is limited by guarantee, this clause defines how much liability each individual company member holds. And if it is an unlimited company, this particular clause would not be included in MOA. The fifth one is the capital clause. It lists the information about the total capital held by the proposed company. This particular amount is called the company's authorized capital. Companies are not permitted to collect more money than the amount listed under the authorized capital. The sixth one is the association clause, which is the last clause in contents of MOA. It explains that any individual signing the bottom of the MOA wants to be a part of the association that's being formed by the memorandum. It has to be signed by at least 7 members in case of public company and at least 2 members in case of private company. The signatures also have to be affirmed by witnesses. There can be one witness for all the signatures, but none of the subscribers can witness the signatures of others. All subscribers and witnesses must provide their addresses and occupation in writing. The subscribers to this memorandum are termed to be the original members of the company. Thank you for watching the video.